our meeting today. I see now that we do have a quorum of 4 members, so I'm going to go ahead and start. I'd like to welcome our board members, Andrew Foyce, Reverend Sam Whitaker, Katerina Semenyova. I also see a few members of the public. I'd like to welcome you as well. And we have the staff for the Clemency Board, which is from the Mayor's Office of General Counsel. I see Christina Sacco. Today, our agenda is mostly old business. One is to approve a letter to the council. Second is to review an application for clemency. And the third is to review a document called Release of Information. It's our practice that we have board discussion will occur first, and then members of the public will be invited to comment. So there would be a period for comment by the public as well. And with that, I'd ask everyone, if you're not speaking, if you're not directly engaged in the conversation, if you would make sure that your phone or your device is muted. It just makes for easier conversation back and forth. So with that, we'll go ahead and get started. The first thing I'd like to address on the agenda is the letter to council. Christina, can you project that letter? We had a draft. Talk us through it.
Sorry to interrupt. Can I just introduce my colleague before we get started?
Oh, yes, please.
Antonio, who you'll see on the screen, is going to be taking over for me. I'm actually having a baby in 2 weeks, so another weird thing about Zoom, no one knows, but Antonio will be taking over while I'm gone, and he's highly capable, and I think he's been to at least one meeting before when I wasn't able to attend. So I just wanted to introduce him and bring him to this meeting so he can get a lay of the land and meet everyone.
Oh, that's, well, first of all, congratulations, and really happy for you. And it is a weird thing about Zoom. You just don't know what's, you don't get the full picture in some cases. So congratulations to you and all the best. And we look forward to having you back too, and really appreciate everything you've brought to the rich conversations we've had. So, and then just to welcome Antonio and look forward to meeting you in person at some point once all this crazy pandemic stuff resolves a bit. So thank you for that, Sonia.
Hi, nice to meet you all. Thank you.
Thank you and welcome. Okay, Christina, can you walk us through our letter to Councilman Rowland? And Antonio, you'll be receiving this shortly, I assume.
Sure, happy to. And congratulations, Sonia. Very happy for you, and welcome, Antonio. I'll just share my screen and let me know if you're able to see it or not. Can everyone see my screen? Great. Okay, just a bit of background as to why we're even doing this. The board voted, this was 2 meetings ago in December, to write a letter to council to add a returning citizen seat. We do have a seat for someone with experience in returning citizen issues, but we don't have a seat for strictly for a returning citizen. And so the board voted, and here's a drafted letter. Received a couple of edits from Patrick, and just wanted to be able to take an opportunity to review it with the board and see if they have any additional changes. And I'll take questions from the board first, and then questions from the public. So I will give everybody an opportunity to read through it. Let me know if you want me to increase it or reduce the size.
This is Ilana Suttenberg. Hi, everyone. Happy snow day. I just wanted to note that I do think that in some respects it's duplicative of what already exists, given that there already is someone with a background in returning citizen issues. That person certainly could be a returning citizen if that's who the mayor selects to fill that position. I think it's important to have a diversity of views on the board, but I do think that the background of returning citizens, that expertise exists, and as I indicated, that person could be a returning citizen if that was a nominee of the board. Likewise, a community member, there's really no specification for the background of what that person could have.
Okay. Considering what Ms. Suttenberg has said, I just wanted to open that up to the board to see if anyone had, any issues with that. Certainly, yes, we could have more than one returning citizen filling in that seat. And certainly a returning citizen can fill any one of these seats on the board. And it's up to the board to decide how they would like to proceed.
So this is Emily. I've been thinking about this. I think that there is a fundamental difference between folks with expertise in some of the issues with returning citizens face and somebody who actually has faced those issues, right? When we were talking through communicating with folks and how they can get their records, certainly a lot of us have experience with those difficulties, but I think it would be really, really beneficial to us to hear firsthand what people's experiences are and how difficult it is. At the same time, I think the expertise we currently have on the board is phenomenal. So I don't necessarily see it as an either or. I liked that the way that the letter was drafted was adding a seat rather than replacing it. I don't feel strongly about that, but I do think that it is really important to hear the perspectives of returning citizens, and that having someone who actually has been incarcerated on the board could be really helpful and inform how we approach these issues.
Just to add on to what Emily said, I don't mean to interrupt. Sorry, Patrick, I don't know if you're about to speak, but I do think that we also do get really valuable perspectives just in these meetings from members who are not board members, just from members of the public who provided, I think, fantastic insights and expertise into all these issues as well. So I think that we are also getting some really important insights from board members, but also from non-board members as a general matter.
This is Felisa speaking. I think that it's important, and what I was hearing from the community, and I think others have heard it too, is that they wanted parity. There's already a dedicated seat for victims on the board, and for parity's sake and for representation's sake, I think it's important that returning citizens be allowed a seat on the board, because it was an issue that affects them directly. So a person from the community should be a person who's experienced this situation should be allowed a seat on the board and have a voice to say what they need to say on the board. So I think for issues of parity, for issues of representation in the community, that's very important. So that's what I just have to say on that matter. Thank you.
Thank you for that. Are there, Andy, I know this was initially your motion to make this happen. I wonder if you have any comments, or any other board members have comments.
Sorry, I just wanted to clarify. So we're talking about adding a seat, not changing, because I think initially we had talked about just changing the member with a background in returning citizen issues to just being a returning citizen. But this letter, it looks like we're trying to add a 10th member. I just want to clarify.
Yeah, my understanding is that we're adding. I think that was certainly my initial motion.
Okay.
Then I actually think it becomes a little extra weighted towards returning citizens, because yes, there's a victim representative, but there isn't a victim per se. So returning citizens get two, and victims get one. So I don't think it's a question of parity, but the public speaker who spoke about this 2 meetings ago, I thought was pretty compelling and convincing. And we are about the question of returning citizens. So I think it makes sense to have a returning citizen with his or her unique perspective on it. So I would ask the board members to support this letter, which I think is fine.
I totally agree with all of that. I'm just worried about, in terms of voting, are we concerned that it'll be an even number of board members?
Well, that's a good point. We don't have a vice president of the Senate to break ties.
Right.
Yeah.
I will say though, USAO is a non-voting member, but
So are you included in that 9 members?
yes.
Okay.
Yeah. So we're fine in terms of an odd number then.
Okay.
Yeah. In terms of voting members who are not.
Right.
Are there any other comments? Okay. Well, at this point, why don't we go ahead and I guess we can vote to send the letter as approved.
Certainly, I was wondering if we could go ahead and take comments from the public on this.
Oh, sure.
Before we vote on it. Sure.
I have a quick comment before the public comments, and I agree with Emily's comment, just that there are a lot of issues on which we have sought the perspective of incarcerated individuals, and we're trying to approximate that perspective through attorneys or people with prior experience. But the closer we get to the on-the-ground experience, the better things like the application process is going to be, the better the outreach is going to be, and the more realistically we're going to be able to reach the people who need to be reached.
Thank you for that.
Any other comments before we turn to the public? Thank you, Katya. Okay. So looking at the list of participants, as always, we'll go in alphabetical order. For members of the public, we have Ethan Anderson. Mr. Anderson, do you have any comments about the letter?
No comments at this time.
Thank you. Next on the list, we have Professor Ross. Professor Ross, any comments?
Okay, I'm unmuted now. Good. Thank you for reaching out to us. And one thing I would just add to what was already said is that there is an issue about credibility too. I think you're enhancing your credibility when you do this. I was on the Roach Brown show, and that was one of the questions I got early on. Is there a returning citizen on the board? And it was almost as if there wasn't, then nobody believed in the process. That was, the reaction that I got. So I think you are doing yourself a service.
Thank you for that.
Thank you, Professor Ross. Next on the list, we have Matthew Ornstein.
Hi, thanks for having me. I'm Matt Ornstein. I'm from the Network for Victim Recovery of DC. I think I sort of agree with what most people are saying here. It seems like it's a pretty good idea to have somebody who is an actual returning citizen on the board. Although I will say I'm not totally sure I understand or why you have somebody who's a non-returning citizen but a background in returning citizen issues and somebody who's a returning citizen. To me, it just seems to make more sense to just have a returning citizen, and they would sort of cover the viewpoint that somebody with a background in these issues would be able to provide. That said, I was listening to the comments on that there is somebody from the victim community who will eventually be appointed or designated to the board. Has there been any movement on that, or do we know when that person is going to be designated? I guess that's sort of one of my open questions as well, is that I would hope that person gets seated at least in the same conversation as this is being done.
Christina, do you have information on that?
Sure. Thank you, Mr. Ornstein, for your comments. Sure. We're still in the selection process for a person with a background in victims' rights issues. And so that is more a MODA question than an us question. But what we've always done is it's open to the public, and we've constantly stated if there are individuals who are interested in applying for that position that they could apply through the Mayor's Office of Talent and Appointment.
And there's a website for that. It's is it moda.dc.gov?
Correct.
mota.dc.gov. And
thank you.
People are free to apply for that, and we really would like to have the full complement. So definitely support that as well. Thanks for your comments.
Thank you.
I don't mean to interrupt, but can I ask a follow-up question about the vacancies? I noticed some notices posted in LIMS about people who are appointed to the board. I don't know. I think that Ms. Carter was now going to be the person with a background in criminal law, and there was a new person with a background in returning citizens. I don't know if I just wasn't sure if Mr. Foyce was stepping down or what was happening, and I just wanted to seek some clarity, if anyone knows.
Well, I can address that. I have been nominated to a Senate confirmed position in the Biden administration, and the president has a rule that none of his senior appointees are allowed to belong to any outside organizations. So when I'm confirmed, I have to step down. But I'm still a ways away. I was hoping to be confirmed in December at the end of the year, but missed that opportunity. I'm still in committee and still answering background questions. So I think I'm at least a few months away at this point. Moda heard about it, I guess, through I don't know what source, and they went ahead, they misunderstood my situation, and they picked someone to replace me. And they sent that bill to the council, and they told me there was a short deadline on consideration of that. I have not heard back from them again. I told them that I would leave early if that was required, but I'd rather stay as long as I could. I don't know final details or decisions on this. The switching around is the first I've heard of that. No one has said anything to me about that. So that's what I know.
So it's fair to assume right now, Christina, that the board is, as constituted currently, is the operating board, right? And so until
That is correct.
Until
We have not
we hear
heard
otherwise,
anything.
there's a full member, and right.
And
Right.
just, I'm happy to hear that, Andy, because I didn't know we have the 2 new resolutions in committee, and we're planning to go ahead with a confirmation hearing. So I would appreciate a little clarity on this, because we have till March, let's see, 17th, and then they're deemed disapproved. So we have to hold a hearing on the nominations that came down before then. So I guess we can talk offline with Moda about this, but I think the reason for the switch also was that the one Brian Ferguson was nominated, who is himself a returning citizen. And then my understanding is Felisa was switched to the criminal law seat. So that's the information I have.
Okay. So I think there needs to be some clarity, probably from EOM.
And then it sounds like if this happens, there would be a returning citizen member of the board, in addition to
in the
Ms. Carter,
seat,
I know
in the
would have
background.
right.
Yes.
And Ms.
Mhm.
Carter, I believe, has a background in returning citizens, even though she would be in the criminal law vacancy.
Right. She has a background in both, so could serve in either seat.
Understood.
So yes, we don't have any additional updates or clarity on that. It's definitely being handled by Moda and strictly a Moda issue, but we can look into it further and provide an update on what the seats are. But we are aware of Andy's position. It's again something that is typically handled by Moda. We just will dig in a little bit more.
Yeah, I didn't think that they would move until I submitted a resignation letter, but I didn't do that. So I think they moved prematurely, but I want to stay as long as I can, but I also want to be cooperative. So if you guys move forward and I need to resign before March 13th, Sonia, that's I'll do that for the good of the board.
We very much appreciate your service, and hope that continues, and appreciate that you're continuing to stay with us during this period of transition, perhaps. So thank you for that. Okay, Christina, I would, a report back to the board on this would be great. An update would be great. Thank you.
Sure, will do. Thank you all.
Okay.
Um,
Back to any other community members who we want to see if they have.
yes, one more. We have Simone Smith.
I have no comment at this time. Thank you.
Thank you. And I think that's everyone. So I'll turn it over to you, Patrick.
Do we need to vote on this?
If the board would like to, yes. But if there are any additional comments from the board.
If I may just offer one last comment, given that, you know, this is kind of a little bit up in the air right now, but it appears that there may be a returning citizen who or has been a returning citizen nominated to the board. Does that moot out this question at all?
You know, because we don't know much about what's happening with the appointments and Andy's seat, I think we can't moot it out just yet, that the board stays intact as it is. And so I think it's the board's decision whether you would like to vote on this letter now or wait until the seat clarifications are you know presented. But I think from what I understand, Andy, you're not entirely sure when the appointment would come through. So based on that, I don't think the seat movements is a possibility. But again, this is a MOTA question, so it's totally up to the board. I know it doesn't moot the issue because the issue is still current because the board is what it is right now.
I also think it's important to go forward with this just for future appointments. We will presumably have, if this confirmation goes through, we'll have someone who's a returning citizen now, but that doesn't mean the next appointment will be. So I think I'd still like to move forward with this myself.
There could also be a proposal in the letter to just clarify that one of the seats appointed by the mayor should be a returning citizen rather than an additional seat.
Yeah, I agree. I'm not tied to adding a new seat myself, but I think either saying getting rid of the background in and just saying is a returning citizen, or saying one of any of these seats should be a returning citizen, I would support.
Okay, so is there any comment from other board members on that? So it seems to me that what's in front of us is add a seat that is definitely a returning citizen and keep the seat that is someone with background in returning citizen representation, or just changing the current seat to is a person. I don't know when the board was initially formed whether the language was specific for a particular reason. I don't know if others can inform me on that.
From the drafting perspective, it was not intentional that it be background rather than a returning citizen. I think the intent actually was to have a returning citizen. So, you know, speaking, you know, I've spoken with my office and we're completely on board with having a returning citizen and changing that to be more clear that it should be a returning citizen. I have not spoken about adding a member to the board, so for what that's worth, but yeah.
Patrick, if I may, it's Betsy. Hi, everyone. Hi. I just want to say that the administration heard you loud and clear about wanting a returning citizen, and that helped prompt the nomination of Brian Ferguson.
Thank you for that. Yeah, we do appreciate that. So board, we have a letter that says add a new board member. We can vote on that. And if you want to do something different, we can say no to that at this point. I think that's probably the clearest way to proceed at this point. So we have this letter. Does anyone might want to make a motion that we go ahead and send this to the council?
No, Patrick, I'll go ahead and make that motion.
Thank you. Is there a second?
I'll second it, Patrick.
Thank you. It's been motioned and seconded. All those in favor, respond by saying yes.
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 Those opposed? Those opposed?
We're non-voting.
Yes. Understand. Thank you. So we'll go ahead and send the letter as is, which is asking for a new board member. Great. The next item on our old business agenda is to look at the application for Clemency. Christina, you have I think a red line copy that you can present for us. We'll kind of go through this, and we'll use that same process where we'll go through and see what it is. Board members, feel free to ask questions as we go, and then we'll ask for public comments at the end.
Okay, sounds good. Give me 1 second. Just want to make sure that everyone, if you are unmuted, to please make sure you mute your microphones. Thank you. Can everyone see the application?
Yeah. Yes.
Great. So this was sent out to the board, received comments from both Ilana Suttenberg and Patrick Canavan. So it's been redlined with their edits and comments, which I'm happy to go through and address with the board. But I just wanted to see whether or not there were any outstanding overarching questions before we began our review.
I have one overarching question. This is Emily, and I'm sorry if I've missed a step here. One thing I was trying to think through when I looked at this is, you know, we had the previous lengthy conversation with regard to the regs about whether or not the application needs to go through OPA, et cetera. And where we had landed, as I understand it, is that realistically in the short term, an applicant really needs to have filled out the OPA application in order to be considered by the White House. And so it seems to me that during that short-term period, it makes sense for our application to be extremely streamlined to just sort of supplement the DOJ application. But that if we get to the place that we're hoping to get to, which is that applications can come directly to us and not go through DOJ, because we could have a much more streamlined application than DOJ does, and one that's easier for folks to fill out, but that may require more than what we would have as a supplement to the DOJ application. So that's a long way of saying is, as I understand what we're considering today is sort of the short-term version of the application, as long as we're living in a world that somebody needs to fill out the DOJ application. But that if we can get to a point where they don't need to fill out the DOJ application, we would be considering a different version of this application.
Happy to take that question, Emily. So this application was created just as an application for a letter of recommendation. It has no connection with the OPA DOJ application, as you know, I'm sure you're aware of. The application is just an application for a letter of recommendation, not a letter of granting clemency. So we have no connection with whether a person has filed an application with OPA, but we encourage, because since we don't have the authority to grant clemency, that individuals can apply with OPA for clemency, because ultimately that is the governing body and the president's the only one who grants them. And so our letter can be supplemented into that application to help support that application, whether an applicant chooses to do that. But ultimately, we'll be forwarding that letter to both OPA and the president to be included in an application if it is there. And whether or not it's there, it would still be sent up for consideration. Ultimately, the goal is to build out a clemency board that has the authority to recommend clemency, for instance, if the mayor were to become a governor, where we would have that authority over, the District of Columbia, but we currently don't have that. And when that time comes, that is ultimately going to require a revision of the regs again, a revision of the application, and it would be an entirely different application.
Yeah, although thank you so much for that, Christina. It's really helpful. I do think that there's sort of an interim alternative that we're hoping to achieve, right? Obviously, we're not a state, and at some point it would be wonderful if we were a state and we had a governor that could grant clemency. But it does seem to me that there's an interim world that we're hoping that at some point we live in, which is that maybe we're still not a state, but that the White House agrees to consider recommendations from us that don't include an OPA application. As I understand it right now, realistically, if we want the White House to consider a recommendation of clemency, the White House needs to also see the OPA application and recommendation. But we think in an ideal world, the folks should not have to fill out the DOJ application because it's too cumbersome and difficult to gather all the information. And so if we get to a place where the White House agrees that it will consider applications directly from the Clemency Board, or letters directly from the Clemency Board that include our application but not the OPA application, that we may want our application to be more fulsome than it is right now, but not as fulsome as the DOJ application, or not as cumbersome as the DOJ application, I should say. So as I just wanted to frame it as I'm looking through this application, I'm thinking of it as a supplement to the OPA application, but that we may want to revisit this if we can convince the White House to consider applications that do not contain an OPA application. And I just wanted to see if others are on the same page about that, or if we think, no, this should be the application that should exist even absent an OPA application.
So from my, and certainly you can open this to the board, but from my understanding is that we are not this application would not supplement the OPA application. Ultimately, our goal is to have that conversation with the White House, and we want to prepare everything until we have that conversation. So in preparation for that conversation, we certainly want to say, here are our regs. Here's the application that we've drafted that has certainly considered the District of Columbia, because currently the OPA application does not factor in the District of Columbia at all. And so it kind of leaves this, jurisdiction unaddressed. And so hence why we are developing this. And so if the board thinks it needs to be more fulsome, that's exactly what this meeting is intended to do. This is not the final application. It's a draft, and we can build it out, make it more fulsome. But ultimately, the idea is to not make the application burdensome to applicants, and make it easy to fill out, and remove as much legalese as possible from applications, because from the looks of things, a DOJ application tends to require the help of an attorney to fill out.
And I just put in the chat a link to the commutation application. I think there's different pardon and commutation applications within the pardon attorney's office, but I think it actually is fairly straightforward. It really kind of asks, like, what were you convicted of, other arrests, convictions, et cetera, and why, kind of a narrative summary. I really defer to others as to kind of how to do it, but I agree with the comment that, and this is one of the comments that I made to Christina, that we really do need to emphasize to people and make sure that they understand, if you do not fill out the pardon attorney application, you will not be granted clemency or a pardon. And I think that making sure that that's very clear is important.
Yeah, I agree with Alana's comment just on really putting in our application the need for the DOJ application, because otherwise we're confusing people and they're not taking the steps that they need to take to be considered by the president. And they're spending and investing a lot of time and energy and effort into an application that may not get them the result that they want to get. And then it's just unfortunate and confusing. So if we put it, front and center, that this is additional, and if such time comes that it's not additional, then we change it. But it really, people really, really need to know that by doing this, they are not doing the DOJ application, and the White House requires the DOJ application.
Thank you for that. Other comments? Andrew, you need to come off mute, I think.
Oh, okay. Thank you, Patrick. I agree with the last two speakers as well. But I would also ask Emily, what, if anything, do you think we're missing in this application as drafted that you'd like to see in the, in the new world? So, it may be important for us to consider adding it at this stage as well.
Yeah, I'm actually not sure about that. So I wonder if maybe as we walk through it, I just wanted to make sure that I was thinking about it in the right way. But if we think that this is just complete with or without the DOJ application as a board, that's helpful for my thinking as well.
Well,
Okay.
thank you.
Thank you for that. Any other comments from board members? All right, so Christina, can we add a line where right below the first paragraph, you do not need to be a resident of Washington, D.C.? Right below that, could we add a line that says something like, please note that you must complete an application for the U.S. pardon attorney, put the proper name and put the link to it as well?
Sure, certainly. I think that's a great idea to put in, and I'm totally in agreement with that. I think we boldened that information here about the fact that the mayor is not a governor and that the board is strictly recommending it. I'm happy to add that to the bolden language that in order to be granted clemency, you need to complete a application with OPA, and here's the link.
Yeah, I would put that at the front of that bolded section, okay? You must complete an application with OPA. And then I think all the explanation of that I think is appropriate then in bold.
I think it should be as part of the questions, because I think people might just skip the preemptory language. I'm not sure if that's what you were saying too, but that is part of the question. Have you filled out, like as number, so if you go down from where you have the screen now, if the question one is, have you filled out? Sorry, I can barely see. Have you?
Sure, let me make it here. Have you submitted an application?
Mine at the same time, but then I can't see you. Have you submitted an application for pardon? So I think it's there.
Right.
Yes, no. If not, if your answer is no, then here's what you should know. And that's right, because that puts it right there where people are doing the application. And I think that's when they're focused on what they have to do rather than reading the peremptory statements.
So that's it. How about if we do both? Change that, make the note if no, make the note really explicit as well.
Sure.
And I'm not sure if this is an electronic form, but that could also be a good place. If the answer is no, then you could just link to it from there.
Yeah.
If somebody's able to figure that out from a technological perspective.
Doing a link is great. And then if we just even put the address, because people can pull it up. Hopefully if they're incarcerated, they can have access to that sort of website. And then people can just take that step immediately.
Yep. Great. We'll just wait for get this in there.
I will add in the link. And then going back to Patrick's recommendation, if no, please. Please.
We could say under, you must file. Under current law, you must file an application, which can be found at this website.
Okay.
Okay, I think we forgot law just above please note under current law.
All right.
Yep. Okay. Let's go back to the letter. We've talked about the first two paragraphs. Is there anything else in the opening preamble, which I know few read? Any comments about that the next paragraph? Clemency includes two forms of relief. And how to submit an application paragraph. Okay, you see the links were updated. Okay, great. Okay.
Can we go back for 1 second to, I think, question 3? Are we on question 3?
Not yet. We're going there now.
No, sorry. Okay.
We're getting to questions now.
We're just in the
let's go.
introduction portion.
Let's go back, please, to clemency, the first bullet, pardon, the next to last sentence on the sub-bullet, the date of your conviction and the date of you submitted. There's something wrong there. It either need of your submission or cut the of. Yeah, there you go. Okay, thank you.
Thank you, Andy.
Okay. Anything else on that first page? Let's go to the instructions then.
I see the addition of www. Oh, hold on, sorry.
I see the addition of the www, but I actually don't know if there's a www in the website.
I don't think there is, but these are comments that can be, that were added. And so Patrick, FYI, we don't have a www, it's just clemency@dc.gov.
Okay, but that says clemency.dc.gov.
Yes, that's correct.
So that's what you type into
No.
Google?
Yes. No, pull it right up. There's no www.
This newfangled technology.
Okay, so these are the actual application questions. So what we're typically asking here is that we ask, the instructions are for the applicant to please provide as much information as possible. If the Clemency Board has a question about your application, we'll reach out to you using the contact information provided. If we're unable to contact you and your application remains incomplete, your application may be closed after 6 months from the date you submitted your application. So that goes back to the instructions and the regulations. Any questions about that? Oh, okay. So I thought I would just go step by step with the questions because they are a bit, they do bifurcate in some way based on whether an individual has a pardon or a commutation. So the first question is, have you submitted an application for a pardon or commutation with the U.S. Department of Justice? I think the only thing to add here is Office of the Pardon Attorney to make it clear. If you're unsure, you can check your status here. And so there's, Ilana, correct me if I'm wrong, that's the correct link for checking the status if there's an application. Is there another way that individuals can also find out whether or not they have an application still pending other than through this website?
Don't know. I'll look.
Okay.
See if I can figure it out.
Thank you. From our discussions, we just know there's this website that's available publicly for individuals. So if yes, they'll continue to know. If no, please note under current law, you must file an application for clemency with the Department of Justice, Office of the Pardon Attorney in order to be granted clemency. The application for clemency can be accessed here, and I will add in the link. And then you would continue to question 4. So let's start with yes, which is continue to the next question. When did you apply for clemency with the DOJ? We would need to know the date just to get further information. And then it asks later, for what offenses did you apply for clemency with the Department of Justice? describe the offense, please be detailed. For example, I applied for clemency for a DUI that I received on this date in Washington, D.C. I believe, Ilana, you recommended that we don't use this offense, that it may be.
I recommended just a United States offense, not a district offense. Like ADW, murder. There's a lot we can pick from.
Okay.
And maybe an older date, given some of the like some of the limitations on when you can file, just might be helpful. That's not illegal.
Okay. Any comments from the board about adding in those changes?
I agree. I mean, because we're not, if it's a district offense, it's going to not go through the president if it's an OAG offense. Is that right? Yeah, it doesn't, yeah, I think it becomes really confusing if it's, I don't know who has the authority to grant clemency on those.
I don't have a clear answer
Do
to
you
it,
know?
but I know that for an offense against the United States, it's the president.
Right, but what happens for the district offense? Yeah, it's totally unclear. Maybe, I think we probably need to research this for people who may apply for district offenses. For DC code offenses that are prosecuted by the Office of the Attorney General, who has the authority to grant clemency.
Okay. And so what would be the suggested language to put in here? Because as an applicant, how would you know the difference between a district and a US offense? Would we want to put clarifying language on that?
I don't know that it needs to spell it out there. I think you could just use, I don't know if people have a preference, murder, assault, robbery, whatever people want to do. There's a lot.
Okay.
It's
Assault's a
definitely
good
the
idea.
majority. Sorry, go ahead.
I was just gonna agree. I think assault is a good idea. It's not too serious. It's not too petty. Everybody understands what it is. That's my suggestion.
Okay. And I'll just move this to like 1990. Is that old? A little older? Okay. So we're up here that if they do not have a DOJ application, they go to question 4, which states, for which of the following are you seeking a letter of recommendation from the district's clemency board, a pardon or a commutation, just as a fact. So if it's a pardon, we need to know, did you go to prison for an offense that you want a pardon? And the answer is if it's yes, there's a 5-year waiting period. So if it hasn't been 5 years since they were released, then they're not eligible to apply at this time and they would have to wait. If they did not go to prison, then it has to be 5 years since an applicant was convicted. And if it's not 5 years, then they would be ineligible. So that's for pardons. Any questions about that? This is all statutorily required, by the way. Okay. Number 6 asks, what offense are you seeking clemency are you seeking for clemency that the board may provide a letter recommendation? Please be detailed. For example, I'm seeking clemency for, yes, in this case, we would do assault again. That I received. So we would want to know in greater detail what they were seeking a letter of recommendation for. The next questions ask, are you currently challenging your conviction or seeking review of your sentence through appeal or other court proceedings? And I believe, Ilana, here you stated.
Yeah, just sorry, back to question 6. Maybe it should be assault I was convicted of, just to change the word received, just to clarify.
Okay.
But yes, I was just tracking the statute in this respect. The statute doesn't create the bar on filing if you're currently challenging it, but rather if I forget if the other relief is available. So I just think that this should maybe track the statute a little more closely, to the extent that the purpose of the question is to kind of see if this other relief, judicial or administrative, is available to this person.
Okay, so are you so from what I understand is if they're currently seeking that, they would also still have to wait it out until, for instance, if they had an application for compassionate release currently pending, that in that instance, they would not be eligible. They'd have to wait until that occurs. But I think you are correct that even if there are other forms of judicial relief available, that they should pursue those before coming to the board. Is that what you're stating?
That's what I'm saying. And I will also say that I understand that this is a little bit legalese and technical, and people might not, I recognize that people might not necessarily know if there is another form of judicial relief available as a non-attorney. So it could be styled a little bit different. And I kind of defer to the board as to whether you wanted to find it out all out via this question, or we're trying to really find out if there were other avenues available to this person. But I was just noting that the board, or the statute, creates a broader limitation than just the currently challenging.
No, totally in agreement with that. Part of the reason why we phrased it this way was to remove the legalese, to make it a little more understandable. But if the board thinks they want to flesh that language out more, we're happy to do that, possibly in another question, just to make these questions a little simpler for folks.
Yeah, as a non-lawyer, I would tell you simpler is better. And what we really want to do is expose if there's some issue here that they need, that we either need further information for, or that they should consider as they apply. I like us just to ask plain questions that would get at that, and then direct them as we need to.
Another recommendation we could do is if, we could do the homework ourselves and ask, have you applied for compassionate release? Have you applied for this? And just all of the administrative remedies that could possibly be available to someone in the District of Columbia. And happy to do that. Obviously I'd defer to the prosecutors and public defenders on the board here for your advice on that.
I'll just note that there's a lot of options that, and it might be hard to kind of try to list them out, kind of seeing that some wouldn't be captured there necessarily, but I kind of defer. I don't have strong preferences on it, but just note that there could be a lot of various options depending on what it is you're seeking, etc.
I think we could say, for example, like use the most common ones, for example, for relief under the Incarceration Reduction Amendment Act or compassionate release. Right, we wouldn't be listing every possible avenue of release, but I think it would help people sort of flag the issue for them that there are these other avenues, and maybe if they haven't researched those, they will.
And those two would account for the majority of options people are seeking?
Yes, I mean, there's Rule 35 also that's more time limited. And then there's collateral attacks on the conviction, 23-110. But I think that the compassionate release and the Incarceration Reduction Amendment Act would be the primary vehicles that people would use. And there's also record sealing relief that does some of the same stuff. But I think that's
right. If we could get something that hits, 2/3 of most people's, issue here, I think that would be a great example.
Or if it's most acute, perhaps for people who are incarcerated, and so the two sort of avenues that are most open are compassionate release and the Incarceration Reduction Amendment Act.
What if we, following this question, added in, have you applied for compassionate release? If yes, no, let us know the dates, and then have you applied for I guess it would be judicial relief through the Incarceration Reduction Act?
I think you could say, I mean, do we want to have the dates?
I'm sorry, the dates, oh, the dates that they applied for, or
Right.
yeah, certainly we can add that in the if yes, tell us when. So for instance, following this question, it would say,
This doesn't necessarily capture the full statutory limit, but you could also just rephrase the question to say like, are you currently challenging, et cetera, or have you previously challenged it? And then we kind of know if that relief has been exhausted. People could say what they've applied for, whether it's been granted or denied.
Yeah, I think if you just put, for example, instead of, I think if you pull out compassionate release and IRA, it looks like those are the only avenues. So if you say, for example, seeking review of your sentence, for example.
as in here, for example, like we did above.
No, after or seeking review of your sentence through appeal or other court proceedings. Maybe that's what you're saying. I can't see the cursor, sorry. Or other court proceedings such as a petition for compassionate release or sentence reduction under IRA.
And just to clarify, the statute says that if there are other forms of judicial or administrative relief available, not have they applied for them. So even if they haven't applied for them and they're available, that's still a limitation. So we might need to rephrase the whole thing. Like, I think we should keep this question, but it's not the full limitation is all I'm saying. Like if it's available out there and they haven't applied for it, it still precludes them from applying.
And I think that's where the challenge comes into play, right? For an applicant is how would they know what's available to them without the assistance of counsel? And that's certainly something I think is a bit challenging for someone who's incarcerated or even someone that isn't.
And this is a broader question. Who's going to be the one who determines if this person has basically exhausted other judicial or administrative relief? Is it the board?
Well, because it's statutorily required for us to, do that, we will have to look into all of these avenues. And part of that, one of the ways we can do that is by asking. And so I think most of the fact finding occurs right here in this application. And I think one thing we do have to highlight is maybe indicate, maybe a question that says, have you sought all judicial remedies that are available to you for your conviction? I don't know how that would work, but it's certainly
having that question and then saying such as XYZ, like compassionate release, IRA, etc. And then obviously if they say yes, then we know. If they say I don't know or no, then we have to look into it, I guess.
So have you exhausted all judicial remedies?
Judicial or administrative relief, for what it's worth in the statute.
To challenge your, certainly this would be for someone who was, okay. And I guess here you said such as include that information again for a compassionate release and but I should say this is not an exhaustive list. Just to name a few.
And maybe it would be helpful to like within like provide a link or something just to kind of tell people like basic criteria for each of some of the most common ones, like compassionate release, and just kind of provide a few of the big criteria, and people can say like, yes, no, I don't fall into that IRA kind of basic criteria, not even necessarily a check mark for them to click off, but just if you can like hyperlink it somehow to the very bare bones eligibility so they can know if they fall within those, or like if you know, actual innocence, have you filed post-conviction relief on that basis, and kind of spell it out a little bit for people.
Okay.
I think it might just help the board
Online could
later
just link to the
ascertain.
statutes.
Sure.
Okay. No, I guess we could put it here. Here are links to the various judicial or administrative remedies available.
Or just like links to some examples, because it's not going to be inclusive necessarily.
To okay, and I will add in the link. All right. Any other edits on these two questions?
Yeah, Christina, the first line of question 8 where it says you convicted, I think should be your conviction, should it not?
Oh, thank you. Thank you, Andy.
I think your conviction or your sentence.
Thank you. All right. I guess the same goes here. Conviction or sentence on these. Oh, I think this could be removed.
Yeah, that seems redundant to me based on
Redundant.
adding the second question.
What about now?
And can I see number 8 also now?
Sure.
So as a non-lawyer, I don't understand really the difference between number 7 and number 8.
I think what number 7 just goes to, are you currently challenging your conviction or sentence? And this is just to say, have you exhausted all your judicial remedies, which is just the requirement to add in that they know that they are required to exhaust all of their remedies. I think this maybe under no, we would say, please note under the Act, the Clemency Act, you're required to exhaust all your judicial remedies before applying for a letter of recommendation. Here are the links to some of the judicial or administrative remedies available. Some, not all.
But
And
wouldn't number 7 be included in this?
It certainly would. I think it's just about like digging in and fact finding about number 1 just asks about what you're currently challenging, and then number 8 seems more broadly to include things that you've challenged before and whether you've exhausted all of those that are still currently available to you. So I think we could say, are you currently challenging or have challenged in the past? We could add that here so we can include challenges that they've made, and then here would just ask about whether or not they're aware that whether or not they've exhausted all of their judicial remedies. I think we do need to ask that question because
Statutory.
exactly.
But
Yep, Sonia?
like compassionate release isn't a challenge to your conviction.
No, it's an administrative relief.
Right. So
we would remove it from here.
I mean, I think these two questions could be combined into one question, but we just have to, like, are you currently challenging your conviction? I guess you're sort of seeking review of your sentence through compassionate release. I don't know. But I think they could be combined into one question. I just don't know how quite off the top of my head.
Okay. Well, we can certainly work on that bifurcation. There's no need to rush on this application now or to vote on it, but we can work on clarifying that and bring it up for a vote when it's ready. So if that's what the board would like to do, but I certainly think that it would be nice to separate the questions out, that what are you currently challenging and have you exhausted all of your remedies? I think certainly that needs to be divided out for sure. And maybe if we remove this information about compassionate release and just let them tell us whether or not they're currently challenging anything, and put the information about compassionate release and the Incarceration Reduction Act here, to let them know that these are administrative remedies available to them and that they are required to.
Yeah, I like that. Just having like challenging the conviction as one question, and then the second question, the other administrative things.
Right. We want to educate them, but we don't need to beat them over the head with the education.
Right.
And I do think that the part of question 8 that kind of asks about past relief that they've sought is really helpful to the board in assessing whether they've exhausted. If it's the board kind of making that determination, the more information that you can gather in the application as to that question, the better.
Right. Okay. I'm concerned about time today. It's 11:39, and we had scheduled this, I think, for an hour and a half. So we're about 20 minutes from our limit, and I think it would be helpful if we go through all the questions though on this part, and then the contact information stuff seems pretty simple, but why don't we keep going? But
sure. Okay. The next question asks, do you have any pending criminal charges or fines that are unrelated to the pardon or commutation you are seeking? That part of this is just finding out that, you know, what's their criminal record, and digging in more to see what we can get from applicants. Certainly, you'll see as we go further down that the application also requires a background check on each applicant, which we will do as well, but that's what's asking here. And I think, Ilana, you stated that it may be helpful to clarify that the applicant should include all pending cases.
Yeah, I had a few comments. First, it doesn't necessarily exclude it, but I thought it'd be helpful to just say pending cases in DC or another jurisdiction, just in case people think that we're just asking about DC. That can actually help people, because I think they don't want to kind of be viewed as hiding something if the question was unclear. And there was a question about fines. If we're asking about fines, that's a little different from the criminal charges. And I didn't know if you also wanted to ask not just pending criminal charges, but in addition to probation, supervised release, parole, if they're on any of those forms of release at the time. And then the last comment that I made in a separate bubble, we said unrelated. And I think the relevant inquiry is whether they're subject to any pending criminal charge that's relevant to the conviction as determined by the board. I thought the word unrelated kind of inserted a little too much subjectivity by the applicant as to whether it's related or not, when in reality, the relevance question is something that's statutorily required to be determined by the board. So just asking if they have any pending criminal charges or on any form of supervision.
Okay, and sorry, state that again, or any form of supervision?
The statute says that pending criminal charges have to be considered. So I think that asking about that, you know, you could just say, do you have any pending criminal charges in DC or another jurisdiction? And I don't think that the statute requires a question about probation, parole, supervised release, but I do think that that might be relevant for the board to know as well.
Okay. Sure, I certainly see we could have that as a separate question about supervision. I think it would be nice to separate them out a bit. That goes back to the simplicity. Do board members have any issue with adding in a question about supervision?
Sounds like a good idea, Christina.
Okay, thank you.
Then there'll be around 10 questions, round number.
Sure.
And sorry,
Yeah, Elon, I was going to you for phrasing. Are you currently under any supervision? Is that more?
maybe, are you under any community supervision such as probation, parole, or supervised release? Though open to others on wording of that.
Such as parole? Sorry, I didn't catch that latter part.
Yeah, something like, are you currently under any form of community supervision, including parole, supervised release, or probation? You can move those around, probation, however you want to phrase it.
Thank you so much.
And then I'd also put in the last comment there that there's a statutory requirement that the applicant not have been convicted of any other criminal offense that's relevant and not be a party to a past or pending civil case that's relevant to the conviction. So I don't know if those want to be separate questions about civil cases and past convictions.
I think part of, I think we can certainly ask, do you have any pending criminal charges, and then ask about civil cases. Are you involved in any? Are you involved in any pending civil cases or have been in the past?
Yeah, and just the statute has a conviction that you have to have not been convicted of any other criminal offense that's relevant as determined by the board. So we might just want to flesh that out too.
All right. I will figure out all the tabbing issues right now. Okay. I guess that would be an 11th question. Do you have?
Okay, I actually do want to clarify my comment as I'm looking back on my previous comments in the statute. I think that some of those only apply to an application for a pardon, not for a commutation. So there might be some different and extra questions for the pardon that might be interesting to the board for commutation, but that I think aren't statutorily required for a commutation.
Okay, so what? Mhm. I guess what I could do is add in those questions and highlight for pardons. So in the green, we've been separating out what applies for a pardon and what applies for a commutation. But I can certainly bifurcate that correctly and then send it out to the board for review, and then we can review everything again at the next meeting. But I just want to clarify the question again, Ilana, that you once stated on here, which is?
So I think it might be worthwhile to just go back to, I was just kind of getting this from the statute of 24-481.05, the eligibility. It has certain application criteria that the board have to require the applicant to address. So I was just drawing from the statute in terms of what it requires the application criteria to address.
Okay, and no, certainly. And I think we've asked about pending charges, supervision, and this would be a question that I would ask about any pending civil cases. But I didn't know if that encapsulates everything that you were highlighting, or there was anything else that you needed included.
Yeah, so for the statutory requirements for a pardon is that you've not been convicted of any other criminal offense that's relevant. So that might be a helpful question to ask. I think it would be helpful for commutation as well. It's not statutorily required for commutation the way it is for a pardon, though. But it seems helpful. What other convictions have you had?
Okay. I'll add a comment here to confirm. I believe this may be just for okay. I will fix the alignment issues and recirculate to the board. But any other questions and comments from the board? Happy to, after we've considered, I know we're short on time, consider questions from the board, happy to take those from the public as well. So turning over to the board first.
On the question 11, I understand the need for it, but I wonder, and I'd like to hear from people who are familiar with defendants more than I am. Are folks going to understand what a civil case is compared to a criminal case? Should we be more explicit? Are you being sued? Are you a party to, or are you suing or being sued? Somehow explain what a civil case is.
Any comments from the board members in this area?
Yeah, well,
Yeah,
I agree with Andy, because if we're going to make this user friendly, they might not know.
Right.
And that's who we trying to get across to the inmates. Well, I mean, everything that we talked about and went back and forth. I'm thinking about what are our residents that are incarcerated going to do, because we're going back and forth.
Right.
And if we're going back and forth and they're reading on another level, they might just get frustrated with this.
Right. Right. Yeah, there's a kind of a plain language requirement too, that I think it's got to pass that kind of sniff test and be at whatever the, grade level of education.
I think we're getting a lot out of that.
Yeah. Yeah. Here's what I would recommend. is if this could be reviewed one more time, and I would say maybe a subgroup of the board, and particularly people who have, real interest in it. I heard from a number of you today, so maybe there could be a small subgroup that would go back and hash this out and come back with a recommendation to the board that we could see in a week or so. Is that possible?
Certainly, who would like to be? We have an application committee. So that consists of Reverend Whitaker and Emily Gunston. So if there are additional board members that would like to attend.
Yeah.
I can attend. I know I have a lot of thoughts.
Yes, thank you. Hey, Katya, it may be worthwhile for you if that's possible.
Yes,
Okay.
it is.
All right, so what I'm going to recommend is let's go push to the subcommittee. You're going to pay attention to all of the legal matters that really, I see this as the screen to say, are you eligible to really get information or for you to apply to this process? And you're going to make that screen as legally sufficient and plain language as you possibly can. And that's what you'll present to us in, let's say, 2 weeks. So that if we could go there, that would be great. The contact information, there wasn't a lot to change. Now, I'm not sure if you want to do that same process with the application for releases, the various releases that we're requesting, that same kind of screen. Is that possible to do in a week? And could the board meet again 2 weeks from today so that we can finalize this? It's a question of board members. 2 weeks from today would be the 21st of January. And I would say 10:30 a.m.
Yes.
I've seen 3 yeses so far.
That's good.
4,
Works for Emily.
5.
I may or may not be here, but if I am, it works for me.
Okay.
And probably works for Antonio if I'm not.
Thank you. Okay.
I can do that. This is
Okay.
Felisa.
Thank you. So I think I've heard everybody say that we could meet today. Is that, Sam, are you as well?
Yeah, I was just checking my calendar.
Thank you. So what I'm going to suggest we do is 10:30, January 21st. We block 10:30 to noon, and you'll come back with us a draft maybe next week, close of business, next Friday, a week from today. Does that sound agreeable to everybody?
Yes.
Okay. Very good. So with that, I think our business is done for the day. Honestly, I have a dead stop in 3 minutes. So if we could go ahead and adjourn for today, and with that caveat that we'll regroup in 2 weeks from today.
Sure. I just want to add one question that came through the chats from the public, and that's from Professor Ross, who's asking for a copy of the application, which was a question for the board. So.
Yes, I think that would be fine. To go ahead and make that available. I want Professor Moyd to know I'm hearing her in my head constantly through this conversation about making this as simple and plain language as we possibly can, and to not put any undue barriers. I do think that there are some threshold questions that says, yep, this is the thing for us to handle or not. And to make that as plain and less legalese as possible is really our goal.
I think that's really important, and I appreciate that. One thing I will remind the board is that we did draft an application, and I think that, some of the language that we used in our draft, just kind of making it plain and simple for people who are going to be trying to fill out this application might be worth taking a look at.
That's an awesome reminder. Thank you. There was all that work done by the law students at Howard University Law School that we so appreciate. So maybe that could be part of the consideration that the board takes next week in the subgroup. Thanks for that reminder.
I'll forward it again,
Great.
what we put before. I think there are things that you could use. The number one issue, I think, too, is that it should not be one application. It's very confusing as one application. Commutation is a really different application than a pardon. And that would help a lot for somebody filling it out.
Okay, great. Thank you for that. Yeah, so forward along, please. Okay, with that, is there a motion to adjourn?
I move we adjourn.
So moved.
Okay.
I'll second.
Moved in second. All those in favor?
Aye.
Aye.
Great. Thank you all so much. We'll see you on January 21st, 10:30 to 12.
Thank you all.
Nice. Thanks,
All the best,
everyone.
Sonia.
Thank you.
Sonia, all the best.
Thanks. Bye.
Yeah.